from the Delamy Law Firm, and I am live on Facebook, YouTube, and Instagram. So finally, I think I figured Instagram out. So, for those who do not know me, my name is Ifama Odolami. I'm an immigration attorney from the Odolami Law Firm in Cedar Knolls, which is close to Morristown in New Jersey. My firm represents clients in all 50 states of the United States. And today I want to talk about something of frequently asked questions, but frequently made mistakes as well. So for those who don't know me, my mission and my passion as an immigrant is to help my fellow immigrants to get legal status without falling afoul of the very uh, 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 what's the word now? The very confusing immigration system. So today I want to talk about something that happens all the time. I've heard so many questions on this, and I want to help you guys clarify it because we want our fellow immigrants to be informed, because when they're informed, they are knowledgeable, and when they're knowledgeable, they're empowered, and when they're empowered, they can get their green cards with a minimum amount of stress and with hopefully faster than it would be if they made mistakes. So we're going to talk about immediate relatives, right? Immediate relatives of U.S. citizens, right? So who can you file for? And I'm not going to talk about everybody you can file for. I just want to talk about certain mistakes that people make because they're not really aware of what the process is with regards to filing. And the reason is because some of the immigration laws really make no sense. They're just the laws. That's what it is. You can't really, think through it and decide, okay, if it happened in case A, it would happen in case B in the same way. That's not how it works. So the first mistake I want to bring to light is those who are filing for their parents. So if you're a U.S. citizen over the age of 21, you can file for your parents, right? Now, filing for your parents means that you have to file a separate petition for each of them. So you cannot file one petition for both your mother and your father. They're two different people. You have to file two separate petitions. And you're going to have two separate filing fees and two separate processes. So this is funny because there are certain situations where you can get derivatives, which means that you file for one person and the other person is a part of that application, even though you're not filing for them. But this is not one of it. So when you're filing for your parents, file for each parent. And you can file at the same time if you wish. There's nothing that stops you from filing for multiple people at the same time. So now let me talk about the second scenario where people get a little confused. It's when you're filing for a spouse who has children, right? So let me break this down by using examples. Like U.S. citizen, let's say U.S. citizen man, for instance, wants to file for his intending alien spouse, wife, right? Wife has two children, right? At the time of the at the time of the marriage, when they got married, the first kid was 14 and the second kid was 19. So now we all know that U.S. citizen has to file separate petitions for wife and for the children who qualify. So just because you put the children's names in the petition when you file for your spouse does not mean that they're derivatives. That's what we call them, derivatives. They're not. So if you're going to file for your spouse and her children, it's going to be a separate petition for each person. So now there's a little twist in the law. You can only file for your stepchild, which is your spouse's children, if at the time you got married, that child was less than 18 years. So for the 14-year-old, U.S. citizen can file for the 14-year-old as stepchild, right? But U.S. citizen cannot file for did I say 19 or 18? The one who's over 18 anyway. Because at the time the parents got married, at the time that relationship was created, child number 2 was over the age of 18. So child number 1, who was 14, can actually get a petition filed for him by his stepfather. So what are the options for child number 2? Well, there are two options, right? First of all, if they're not married, right, and they're thinking of getting married and thinking of, having their children included as part of the process, it's better for them to file a fiancé petition. So basically, if you file a fiancé petition, all your children under the age of 21 are included in the petition as derivatives. So you come into the US with a K1 visa, and your children under the age of 21 come in with a K2 visa. See how easy that is? But it's important to know this information, because if you go ahead and get married thinking, oh, well, when I get married, I'll file, my spouse will file for the children. Guess what? One child doesn't qualify. But if you knew this information ahead of time, it might be better for you to come in on a fiancé visa, come in with all your children under the age of 21 who are now K2 derivatives. And then when you guys come here, you do the needful, you get married within 90 days, your kids are also going to get their green card because they came in on a K2 visa. So that's why it's important to have this information. So second thing is this. I'll tell you, this scenario happened in my office. This man married to an intending immigrant, 2 kids, one a little baby and another one who was, I think he was 22 or so. So they come in, no, he wasn't 22, he was 19. That's how old he was, 19. So they come in together. Husband wants to file for his wife, also wants to file for his stepson. And of course, I told him, your stepson is over 8. You guys got married just a couple of months ago. So your stepson was already over 18, so you can't file for him. And so what's going to happen is when your wife gets her papers, then she can file for him. When she gets her green card, she can file for her son. But remember, her son is already here, and he's on a visa that has, I think they came in with a visa, he's on a visa that has expired. So he's not going to be able to adjust status because, it's going to be a problem for him. He's not in, he doesn't have a legal status. So he's a green card holder, cannot file for their child, when that child is not in legal status. So problem. But guess what? The more I questioned them, the more I asked them more questions about what was going on in their family life, I realized that this child could qualify for an immigrant petition called Special Immigrant Juvenile Status. So basically, I said, well, your husband cannot file for your child because the marriage happened after he was 18. You're going to have a problem filing for him because as a green card holder, he can't adjust status because he's not in legal status. Even when you become a citizen, he's still going to have a problem with you filing for him because he's not in legal status and because he would be over the age of 21 at that time. So I started asking questions about his father, the boy's biological father. And then I got more information. He was abusive. He was neglectful, basically hadn't done anything for this child. He had abandoned the child and all these terrible things he did. And so he qualified for Special Immigrant Juvenile Status. Why? Because number one, that child who is 19 is present in the United States. He's also single and unmarried. He has been abused, abandoned, or neglected by his father. And we can show, because they're from, I think it's Venezuela, we can show that it's better for him to stay in this country than for him to go back to his country. So that is a happy family. They came for a consultation, and even though they couldn't qualify for one thing, they were able to qualify for something else. So hi, Nkechi, how are you? So now let me talk about children filing for their parents. That's another thing, another category I hear. So you have these parents who come in, they have overstayed their visa or they never came in with a visa. Now there are 2 separate distinctions to be made. If you have a US citizen child who's over 21, they can file for you as a parent depending on how you came into the United States. So if you came in into the United States with a visa that's now expired, that's not a problem as long as there are no other inadmissibility issues, they can file for you. However, if you come in through the border, you're not going to be able to adjust your status based on that child's filing if you don't have another qualifying relative, right? Because children are not qualifying relatives for their parents. However, if you may be able to adjust your status if your child is in the armed forces. So you have a child who's over 21 and your child is in the armed forces, in the military, you may be able to adjust your status through a process called parole in place. And there's another way to adjust your status even if you came through the border. It's that would be if you were present in the United States December 21st, 2000, and there's been a prior petition. Whether or not it was successful or not does not matter, but there's a prior petition filed for you on or before April 30th, 2001. And if that's the case, you can adjust your status through something called 245I. So basically, the bottom line is, immigration law is a jigsaw sometimes. So just because you've been told you don't qualify for something does not mean you won't qualify for another thing. Now, there's another way you can qualify if you came through the border, is by something called VAWA, Violence Against Women's Act. Now, I talk about VAWA all the time, and everyone thinks VAWA is only for spouses, but no. Violence Against Women's Act, number one, applies to men, women, children. So yes, it does apply if you're married to a U.S. citizen or green card holder who's been abusive emotionally or subjecting you to extreme cruelty. Yes, it does apply for children whose parents or step-parents are treating them badly as well. But guess what? It also applies for parents whose adult children, 21-year-old U.S. citizen children who are over the age of 21, are treating them badly in an abusive manner. So I think I've talked about this before. So even though you come in without, you come in through the border and you otherwise wouldn't qualify to get a green card, right? If you have a child who's over 21 and who has been treating you badly, who's been emotionally abusive to you, cruel to you, you might qualify to get your green card without having to leave the country, because otherwise you would have to file something called a waiver, hoping you have a qualifying relative, right? So that's pretty much all I have for today, and I'm really happy I got into Instagram because this is my second time on Instagram, but I'm always on Facebook. And so let me say hello. Hi, Uncle. Uncle Francis is on the phone. Thank you. And Nkechi, thank you so much. So I hope you guys have benefited from this information because, like I said, our passion at the Odolami Law Firm is to educate our fellow immigrants with regards to immigration law so that we can help them get their legal status. So I don't have any other questions, and I have to get back to work. So I will come back again another day. But for right now, you guys have a wonderful, wonderful day. Take care.